one of the things that we've seen a lot this last year is people using, contracts that they developed right when they started their business, which sometimes could be 5, 10, 15 years old. And they never make an update to them. And the problem with that is that when this contract actually comes to fruition in a negative way, where you have to sue or you're trying to get rid of someone, like in a partnership agreement, and it hasn't been updated for 20 years, the rules that were in place in the original contract don't always work anymore. So I can't stress the importance of having your documents reviewed every couple of years just to make sure that they're going to not only comport with the law, because the laws change, especially in the state of California, as most everybody here knows, but secondarily to that, what if you didn't have an attorney's fees provision because 20 years ago you didn't know that you needed to have an express attorney's fees provision to get attorney's fees covered if you have to seek collections on a contract dispute? um, that is a huge issue that we see often, is that there is language missing that you would have in it today, because as the law has developed over the last 10, 15, 20 years, people now know to make sure that those provisions are in the boilerplate or that they're in their body of their agreement, and you don't have it because you haven't even bothered to modify. I do often hear people say, if it ain't broke, don't fix it. But I think that that's not really the right move when you're talking about contractual obligations and you're entering into new contracts on agreements that were drafted 10 years ago.